Now, the National Prosecuting Authority, who you've just heard from there, says they'll oppose the National Assembly Speaker's urgent application to interdict police from arresting her. That matter, as I mentioned, set to be heard in the High Court in Pretoria. Just last week, the NPA raided Mapisa-Nqakula's home in Johannesburg to seek information of alleged corruption. She's accused of soliciting a 2.3 million rand bribe from an SANDF contractor while she was Defence Minister. Let's get you a sense of what else we know. Bring in our reporter, Canny Maphanga, live to us from just outside court this morning. And Kenny, of course, a lot has been said, the story dominating even the weekend papers from yesterday. What do we know about how today is likely to unfold?
Well, good morning to you, Ayanda, and to the viewers at home. Indeed, what you can expect is for the Speaker of the National Assembly to go ahead with her bid to block her possible arrest, or imminent arrest rather, over the corruption allegations during her tenure as Minister of Defence. Now, what you can expect when the proceedings start at 10 a.m., the court is likely to deal with the question of urgency first before it gets to the merits of the matter. So the court must establish if this issue is urgent and if it should be heard further, and whether it will make a determination on the issues brought by the Speaker. We know that the NPA will be vehemently opposing this matter, saying that it is baseless, without merit, and therefore should be dismissed. So when those proceedings start at 10 a.m. this morning, you'll expect that counsel for the Speaker will then spell out the urgency in this matter. You know that she's trying to block that possible arrest. She's listing a number of grounds, including that she feels that this is an opportunistic move ahead of the election. She also lists as concerns that if she is charged and appears rather in that criminal dock, the step-aside resolution that was reaffirmed by the ANC, her political party, at its last previous conference, will immediately click in, and that will have implications rather for her as the Speaker of the National Assembly.
Yeah, and the Speaker doesn't seem to be holding back much, Kenny, referring to this as a persecution as opposed to a prosecution. Real questions also being asked about just procedurally speaking, whether something like this happens, whether somebody can ask for full disclosure of an investigation pertaining to their arrest before they're even arrested.
Well, I think, Ayanda, we've discussed this issue last week as well, when this first came to light that she had filed those papers. In the criminal justice system, there is a process for you to defend yourself in a criminal matter. Usually you have an understanding of the charges that you are facing and the nature of the case that you're facing, but the kind of full disclosure that she is seeking is something that happens towards the beginning of the trial. So while the matter is still appearing in the lower courts, which is where she would have appeared first, it then gets prepared to be transferred rather to the High Court for trial. It is at that stage that you would have gotten that, at least the full disclosure that she seeks. But I can't see an instance where she is fully entitled to the entire docket at this stage before she's even appeared to at least list the charges and enroll the matter in the lower courts. But this is an issue that is going to be discussed ahead of time here at the 10 o'clock hearing in the civil courts when they ventilate this matter, if they decide that this matter is urgent, as whether or not she has a right to claim that full disclosure ahead of the criminal justice system, which works the same for everybody. If you or I, Ayanda, were to be arrested, we would have to appear in that criminal dock, list those charges, and there are processes. Once the state has presented their case for you to defend yourself, there are even options for you to discharge or apply for a discharge if you feel that the matter that has been presented by the state in the criminal court has nothing to do with you. So it really is unprecedented for someone to say that the state has to prove the strength of their case before they can appear before a criminal dock.
Right. What the Speaker's team seems to be emphasizing a lot, Canny, is the fact that information around this imminent arrest was leaked to the media, and therefore they see no problem that all this information be made public to Nosiviwe Mapisa-Nqakula as well. I wonder to what extent the NPA will have to explain how all of this information got to the public, at least at this stage of proceedings.
Well, if you look at her court papers, Ayanda, versus what has been reported in the media, it really is on the surface the issues there. But if you look at the court papers and the affidavits, she has a lot more information than she is letting on. You've seen in the paper she actually described the search and seizure operation that took place at her home. She even lists in those papers that she is of the view that that operation actually weakened the state's case because the listed items that they were looking for in her home, such as a wig, a handbag, etc., were not found. She confirms that in the affidavit. But a lot of that information we haven't seen in the media yet, but was revealed in her court papers. What was revealed in the media yet was that there was a possible arrest and that she was expected to hand herself over to the police. This is quite surface level information, Ayanda, which doesn't reveal a lot about the case. What we have gotten credible, or rather material information from this matter was revealed in her filing that she made in the Gauteng High Court in Pretoria, in a bid rather, to interdict that imminent arrest.
There was a major scramble on Friday when there were reports around her being possibly at a police station in Pretoria. What do we know, if anything, Canny, about whether she'll be in court today?
Well, Ayanda, this is a civil matter. It's being heard in the civil court. She does not necessarily have to make an appearance here. It is only in the criminal court where she would have been charged that she would have to be in the criminal dock. So in this hearing that we're going to hear in the Gauteng High Court in Pretoria, which is an application for an urgent interdict and full disclosure, only the counsel for the parties are required to be present in the court to argue this case. If she were to be appearing in the criminal court, where she would be charged and processed accordingly, that is when you could expect her to be in the criminal dock. But with the kind of media presence here and the concerns she's listed in her filing in the Gauteng High Court in Pretoria, I highly doubt that she'll make an appearance here in the Gauteng High Court as they determine this issue of whether she has a right to seek that full disclosure of a matter prior to subjecting herself to the criminal justice system process.
Yeah, all very important context and so clearly outlined. Canny Maphanga, thanks very much indeed. Canny's live to us there from the High Court in Pretoria.